Data Privacy Protection Privacy Notice Part 1 by Luis Gerardo Ramírez Villela. Hello, this is Luis Gerardo Ramírez Villela, partner of Milgenburg, Orches y Peñalosa. In this video presentation, we will talk about data privacy protection, in particular in connection with the Data Privacy Notice. The federal law on protection of personal data held by private parties was carried out with the purpose of protecting personal data in possession of individuals with the purpose of guaranteeing privacy and the right to self-determination of information. The law on data protection is binding on all persons and companies that obtain, use, leverage, transfer, disseminate, or store personal data in any way. The owner has the right to assume that the personal data provided to the responsible person of the information will be treated as agreed in virtue of the privacy notice. In accordance with the law on data protection, personal data should be understood as any information concerning an identified or identifiable natural person. Data Privacy Protection Privacy Notice Part 1 by Luis Gerardo Ramírez Villela. Hi, I am Luis Gerardo Ramírez Villela, partner of Milgenburg, Orches y Peñalosa. In this video presentation, we will talk about data privacy protection and in particular in connection with the privacy notice. The data protection law was carried out with the purpose of protecting personal data in possession of individuals with the purpose of guaranteeing privacy and the right to self-determination of information. The law is binding on individuals and corporations that obtain, use, leverage, transfer, disseminate, or store personal data in any way. The owner has the right to assume that the personal data provided to the information responsible will be treated as agreed in connection with the privacy notice. Pursuant to the data protection law, personal data should be understood as any information concerning an identified or the identifiable individual. Sensitive personal data should be understood that comprehends all those information and data that are estimated that could impact the sphere of the owner or whose improper use may give rise to discrimination or entail a serious risk to him. In accordance with the provisions of the data protection law, the information responsible is obliged to 1. Treat personal data legally. 2. Act with the consent of the owner of the information. 3. Collect information only when deemed necessary. 4. Inform respondents adequately of information about their treatment. And 5. Act responsibly with respect to data processing. The data protection law provides for sanctions and administrative procedures for violations of its principles, which are punishable by fines or even by criminal actions. The Data Privacy Notice in Mexico is a document through which the information responsible acknowledges to the owner of the data before processing such data that the information that is going to be collected and the purposes for such collection. Data processing must be adequate and relevant in connection to the purposes provided in the privacy notice. For sensitive personal data, defined as data that, if unduly disclosed, would affect the most intimate sphere of the human being, this would require greater protection, and the data protection law provides for special treatment. It should be noted that when the data is no longer necessary for the fulfillment of the purposes provided in the privacy notice, the information responsible must cancel such information. The information responsible must send privacy notice in accordance with the terms and conditions provided in the data protection law. There are three legal figures in the privacy notice: the information responsible, which is the authority, entity, or corporation in charge of processing the personal data; the holder of the information, that is the individual or corporation, who alone or in conjunction with others treats the personal information in the name and on behalf of the person in charge, in example, the Human Resources Director, and the user, which is the person authorized by the person in charge and part of the organization that has access to the data and personal data systems. Data protection law grants the owners of personal data the right to access, rectify, cancel, and oppose their personal information in possession of third parties, as well to oppose its use. These are known as the ARCO rights. The right of access is to use personal information that is in the possession of third parties in order to know if it is correct and updated. Right of rectification refers to the correction of personal information when it is incomplete or inaccurate. Right of cancellation is that the holders of personal data may request that it be cancelled and that to be deleted when they consider that they are not being used or treated in accordance with the data protection law. The right of opposition is that holders of personal data have the right to oppose the use of their personal information or demand the cessation of it. We will continue in the second part of this video presentation and hope this information has been useful. Please do not hesitate to contact us. Thank you.